Welcome to the Litigation Room, where it happens, a Rivero and Mestre podcast. Hi, everyone. I'm Andres Rivero with Rivero and Mestre.
Bryan Paschal with Rivero and Mestre.
Today, the topic we're going to be discussing, we've titled Managing Risk, Liability, and Claims. Does your general liability insurance policy cover you against COVID-related claims after you reopen your business? So what is it? What's the situation that we want to address? I'll take an example. Many businesses are reopening now in all parts of the country, and as they reopen, certain businesses or business owners or their contractors are, for example, taking body temperature screenings of people as they come onto the premises of the business or the building. And one can imagine a situation where later someone gets infected, perhaps at the building or the business, and a clever plaintiff's lawyer comes up with a claim that by not doing the body temperature screening properly, your business or you, building owner, are legally responsible for the infection. So the question we're posing is, in such a situation, does your general liability insurance policy cover you for that kind of claim? And with that introduction and that sort of setting up the topic, I'd like to turn this over to Bryan, who's going to talk to us about the general principles about how you would start to look at whether general liability insurance would provide coverage.
So, Andres, I think the first thing to make clear is that every insurance policy is going to be different. So, any policyholder has to first look at their insurance contract and also consider the law of the state. Every state has different laws. But generally, a general liability policy is going to cover bodily injuries. And bodily injuries, if somebody has an injury resulting from COVID-19, that would be probably considered a bodily injury. And just to be clear, most states have a common thread, which is that insurance coverage is broadly construed to protect the insured. So that's a very powerful tool that an insured has to know that courts will often look to give you coverage rather than take it away. So I think that's the initial question, is whether or not bodily injury from COVID-19 would be covered. And the next point would be whether or not an insured can actually exclude it, affirmatively exclude coverage through one of the exclusions in the policy. And we've worked on many cases like that before. And Andres, you argued in the First Circuit a very important exclusion in terms of the FDIC litigation. In this context, and we're kind of seeing this as a trend with insurers, they're relying on what's known as a pollution exclusion. This exclusion is typically used to prevent like EPA claims, claims for contaminants, gases, things that a pollution that could cause some sort of injury. So somebody gets injured from a pollutant or contaminant. Very common, and again, look at your contract, but the term virus isn't going to be included in pollutions. It's not what you think of when you're considering an EPA type claim. So insurers are getting very creative to kind of, let that exclusion cover COVID-19.
Bryan, let me pick it up there. So if I can just reiterate what you're saying and make sure I'm with you on this. Your general point is, the first thing is that the general liability insurance policy, you've got to look at the particulars of that contract as any contract, but that the law of most states is going to play in favor of coverage as opposed to coverage. And an important part of that principle is ambiguities in the contract will be read in favor of the insured.
Yes.
The second part of what you're saying is that besides looking at the contract to see whether it's likely that there's a covered event, then you've got to look at the exclusions to make sure that that particular covered event's not excluded.
Yeah.
And you referred to some litigation that you and I did in the context of defending bank directors in a case brought by the FDIC, where we were looking to a directors and officers liability policy, a D&O policy, and we ended up making the law on an exclusion clause which is insured. And just commenting on your point, both principles you're talking about were very important. One, that the general tendency is to favor coverage, and second, that ambiguities are read in favor of the insured. And that was critical to winning that decision in the First Circuit that provided for ultimately $100 million of insurance coverage. So Given that construct, that framework, can you talk to us about a little bit more about the particulars about this pollution exclusion? If I understand, that's the one you're pointing to, that might be a problem for trying to get coverage under a general liability insurance policy.
Yeah, so, and you just mentioned it, ambiguities are construed against the insurer. Exclusions are narrowly construed so as to not prevent the insured from getting coverage. So I think it's really important to look at the tools that you can use to kind of get around that exclusion or defeat that argument. And sometimes that requires just thinking outside the box. I mean, we did that with the IVI litigation and the FDIC. Look to what the insurer sells. You could go on the website, look at their foreign policies, go on Westlaw, look in court dockets, find other cases where they filed similar general liability policies. Because in some instances, you will find that there may be an exclusion that does apply to your situation, but it wasn't included in your policy.
Brian, so let me just, if I can jump in there, can you be a little more specific about what we would expect for a pollution exclusion policy to look like? And would it be, like, I know you mentioned the EPA claims and those kinds of contaminants. How would that relate to a virus like COVID-19? Why would that kind of exclusion exclude coverage in relation to a virus? Or what are the arguments on both sides of that?
Well, for the insurer, you can argue that it's a contaminant, kind of like it's a gas or any other contaminant. And on the insured side, I mean, there's a host of arguments that you can make to kind of get around whether or not a virus is considered a pollutant or a contaminant. And I think the first place you want to start is look to what the insurer sells. So if you go on the website, the insurer is going to have foreign policies and endorsements because they're advertising them for sale. And so if you find a product or an insurance policy that has an exclusion that particularly excludes your scenario, here insurers do sell throughout this crisis a virus exclusion. So if you go on their website and you see that they sell a virus exclusion, but it wasn't included in their policy, you can almost use that as an argument to say there's ambiguity here and the insurer knows it because they have an exclusion on point. And, in the IVI litigation or the FDIC litigation, discussing the IVI, that was one of the issues that we argued in the First Circuit.
Brian, so on the exclusion part of this analysis, can you talk to us about in some more detail about this pollution exclusion?
Yeah, so it's an exclusion that's meant to take away coverage for claims arising out of contaminants, pollutants, or gases that cause bodily injury on your property, kind of like EPA claims too. So that's the purpose of the exclusion. That's what it's typically used for. The general purpose of the pollution exclusion is to prevent claims or coverage for claims that are based on environmental contaminants or pollutants. Think EPA claims. So if a gas line were to erupt on your property and cause some sort of injury, or if there was gas leaking on your property and caused injury, the pollution exclusion may actually, trigger there. But in the quarantine, in the insurer's view, that sort of definition, contaminants, could be construed to include a virus.
Yeah, so give me some examples, Brian. How would you develop some arguments about this pollution exclusion and why it does or doesn't apply?
Yeah, so first I would look to see what does the insurer sell, what type of products. And if you go on their websites or if you go in court filings, think outside of Westlaw, think outside of PACER. If you could find a state court filing where the policy is included as a part of a DEC action, for example, look to the endorsements that are included in those policies. Because if you find an endorsement that specifically excludes viruses, which insurers do sell a virus exclusion, and it wasn't included in your policy, that would tend to suggest that there's some sort of ambiguity. Insurers know that the pollution exclusion does not apply to viruses. Otherwise, they wouldn't sell a virus exclusion or viral endorsement. That would be the first argument to help you demonstrate that the pollution exclusion does not apply to viruses. Secondly, go into other filings, it doesn't have to be on Westlaw, any state court filings, and look for similar policies where the insurance company did not assert the pollution exclusion for facts that may be similar. It doesn't have to be the coronavirus. Could have been another virus. It could have been bacteria, salmonella or something. And the insurance company did not assert the pollution exclusion because that would tend to suggest that there may be judicial estoppel. They know that the pollution exclusion doesn't apply. The only reason that they're applying it now is because of the quarantine. They know they have a lot of claims and they need to kind of stave off paying out all this insurance.
I know you got more, Brian, but let me just jump in on that one. I remember on our IVI litigation that you found where our opponent, the insurance company, had actually taken a position contrary to the one they were taking in our case, and you found it in some obscure situation. I think it was an insurance company receivership I think it might have even been a state court filing. Still don't know how you found it, but that's what you're talking about, is find a place where they've taken a position, or either they took a position opposite, or they didn't argue the position they need to argue on this one. So besides those are a couple of good examples. Any other places that you would look to try to find support?
Yeah, again, thinking outside the box, I would certainly look at the state's environmental agency definition for pollutant or contaminant, because it's not likely to include bacteria or viruses, which suggests that the pollution exclusion could not apply. And again, a court will look at the ordinary meaning of these terms. And so if an agency, a state agency, didn't include pollutants or contaminants to include a virus or even bacteria, that would suggest that the exclusion doesn't apply.
Those are some good examples of how to look, where to look, and how to think about developing an argument against the exclusion. Let's turn to what it is specifically, because sometimes this gets lost, especially for practitioners who don't routinely do insurance-related litigation. Talk to us about the difference between duty to defend, duty to advance, and then indemnification obligations.
So initially, when a claim comes in and it's reported to the insurance company, obviously there has to be counsel engaged to defend that claim or negotiate a potential settlement. And so insurance company have either one of two obligations. One is to defend the insured, and one is just to simply advance defense costs for the insured's counsel. Both have the same standard, and it's different in different states. So some could be, for example, Puerto Rico, it's a reasonable probability. Some, if there's a remote possibility. I mean, there's just different standards for different states, but the key here is that it's the threshold for whether or not the insurance company has to pay defense costs or hire defense counsel is always a lighter burden, a much lighter burden, than whether or not the insurance company actually has to pay for the claim.
And the actually having to pay for the claim at the end of the case, that's the indemnification obligation, right?
Yes. Mm-hmm.
Okay. And let me just mention in a practical way to sort of illustrate what Brian's talking about. In this $100 million coverage case that we've referred to a few times, I ended up in front of the First Circuit. We had sought, as I recall, it was the duty to defend, and the other side argued that, in fact, that was an injunctive relief we were seeking. So what ultimately happened was, when I was arguing it to the First Circuit, they asked me, well, what if it is an injunctive standard? So my point to them was, if it was an injunctive standard, that meant we had to show a reasonable likelihood of success on the merits of the claim. And the standard in this kind of claim was a remote possibility, I believe was the one we were arguing. And so I told the court that meant that the standard that I needed to meet as to what the insurer's obligation was under this contract was a reasonable likelihood of success on the merits of a remote possibility of a duty to defend. And I described it as one of the lowest standards I'd heard of in our law. And I think that's actually right. And the judges really took that to heart, and that was very helpful to us because we had a very low standard to meet. I think I was actually critical in getting that decision. Brian, what is the distinction, though, between duty to defend and duty to advance?
Yeah, it's very important here for a COVID-19 claim. So the duty to defend allows the insurance company to hire the counsel that's going to represent you. So you don't really have a say in who's going to represent you. The insurance company will have a firm that they've already contracted with to represent you. The insurance company will also control the litigation. So the insurance company is going to have access to the lawyers or your defense counsels. So the insurance company is going to have access to what your defense counsel is developing as a strategy for the case. So facts, evidence, anything that they have access to, the insurance company is going to have access to. And you're typically, that creates a tripartite relationship between you, the insurance company, and defense counsel. So all of that would be privileged. Now, there are problems with the duty to defend, and that's really important here for COVID-19. And typically, duty to defend standards are found in general liability policies. And the problem here is that if your insurance company is reserving the right to deny coverage for the pollution exclusion, and they may file a separate lawsuit to get out of coverage altogether because of the pollution exclusion, you may have a problem with them also controlling your litigation, and them also, the insurance company also getting evidence from your defense counsel about your particular case under the underlying claim. because that could be used against you in a declaratory action. So separate from that, there's another standard where it could be in your policy that the insurance company is only going to pay defense costs. And those policies, the insured will have the option to select whoever they want to hire, and the insured will be the one to actually control the litigation. And sometimes there could be a tripartite relationship there. But when you have an insurer who's looking to deny coverage, that kind of destroys that tripartite relationship. So it's very helpful to have a duty to advance policy in a situation like that. And also, it's important to note that even if you have a duty to defend policy, if the insurance company is looking to deny coverage, you have a right to depending on your state law, you may have a right to seek your own counsel, independent counsel, and have the insurance company simply pay defense costs.
Ryan, that raises a question to me because we have dealt with some of these issues. Are these general liability policies generally wasting policies?
Yes.
So let me comment on that. So that has significance too, but that would mean that as your defense costs are absorbed, that counts towards your maximum coverage. So if you have a $10 million policy and counsel consumes $1 million in the defense, you only have $9 million available in coverage for the ultimate resolution of the claims. Brian, thanks. I think this has actually been an interesting and somewhat nuanced discussion of these issues. I just want to tell all of you that we love to tell folks when they have any kind of problem and they come to our firm that better days are ahead, and we really believe that. And so stay strong because better days are ahead.
Thank you, everybody.
Thank you for listening to the Litigation Room podcast series. This podcast is intended for general information and educational purposes only, and should not be relied on as if it were legal advice about a particular fact situation. The distribution of this podcast is not intended to create, and receipt of it does not constitute, an attorney-client relationship with Rivero Mestre. Join us soon for another interesting discussion.